Court of the Second Judicial Circuit Criminal Division is now in session. The Honorable Judge Carnwright is presiding.
Thank you. Please be seated. Good morning. This is the case of the State of New York against Blaine Gibson. Mr. Gibson is being charged with murder in the second degree by indictment. He is accused with on or about July 26th, 2023 in the County of Ulster, State of New York, with intent to cause the death of Douglas Chase. He did cause the death of Douglas Chase. Now, to begin, could I ask the prosecution to introduce the team? You may stand up, please, and then introduce yourself and your team.
May it please the court, I am Emma French. This is Anthony Rewalk and Robin White.
Emma French.
Anthony Rewalk.
Anthony Rewalk. And
Robin Wesley.
Robin.
Wesley.
Thank you. You may be seated. And could I ask the defense to introduce their team?
If it may please the court, I am Jonah Nacarado.
Jonah, if you don't mind, when you address the court, would you stand, please?
Yes.
Thanks.
I am Jonah Nacarado with Zeke Wolf and Warrior Darmstadt.
Okay, Jonah Nacarado. And
Zeke Wolf.
Zeke Wolf. And
Victoria Darmstadt.
Armstead?
Darmstadt.
Darmstadt. Like the city in Maine. Please be seated. And you are the defendant?
I am, Your Honor.
And what is your name?
Blaine Gibson.
Blaine. And for the record, Mr. Gibson, how do you plead?
Not guilty.
Please be seated. I'll take the prosecution's opening statement.
Good morning, members of the jury, Your Honor. Today, I will be representing the people in the case of the people of New York State versus Blaine Gibson. Your Honor, members of the jury, today you will hear testimony from a witness to our victim's burial, a well-equipped forensics expert, and a detective from our very own Saugerties Police Department. With these testimonies, we will prove to you all beyond a shadow of a reasonable doubt that a crime was committed July the 26th, and the culprit to that crime lies right before your eyes. From DNA at the crime scenes to witness account to direct location and words of our very own defendant. In addition, you will all hear from an employee of the victim and defendant, as well as a man who discovered our body and the wife of our deceased. With lack of motive from alternate suspects, along with the facts of this case, we hope to demonstrate to you all today the lies of Mr. Blaine Gibson, who, with the intent to harm, killed our victim who was a husband, a father, and a businessman. We come here today not only to put away the criminal, but to also bring justice and peace to the life and the death of a great man. With evidence to back the location of our suspect, the character of our friend Mr. Gibson, and the physical evidence from both crime scenes, as well as direct testimony of witness, we come to you today to ask the question, if you have nothing to hide, Mr. Gibson, why would you lie? Thank you.
Thank you. clients care to make an opening statement?
Today, I am representing Blaine Gibson in the matter of Blaine Gibson versus the state of New York. Blaine Gibson is a man with everything to lose in this matter and nothing to gain. So the question is, who did it? He had no motive or reason. He only stood to lose. Throughout this trial, we'll be witness to testimonies from witnesses such as the wife of the deceased, who has everything to gain from the murder. Mr. Cooper, who had suspicious knowledge of the crime scene and human body, and a wrongfully accused lover of the deceased, who is able to provide us insight into how the business ran. The prosecution will also introduce testimonies from police officers who had failed to investigate the case for. Further, forensics detectives who had also failed to notice certain evidence, and Mrs. O'Neill, who had barely even gotten a look at the murderer in finding the body. You'll be presented with evidence that will surely prove of his lack of guilt and of another person's guilt with life insurance policies and more. Throughout the trial, you will learn how Mr. Gibson, the man who stood to lose everything and lost more from this murder, had managed to, again, just completely lose everything, and how many other people, specifically the wife of the deceased, stood to gain. We believe that by the end of this trial, you will find reasonable doubt of our client's guilt, and if that doubt exists, you must find Mr. Gibson not guilty of murder. Thank you.
To all of you, excuse me, I have a little bit of a cold and I will try not to cough into the microphone. Would the prosecution call you first witness, please?
Our first witness is Ms. Leanne O'Neill.
All right. I can do it when you do it.
Please raise your right hand. Do you swear the truth? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Excuse me, Ms. French. I didn't catch your name.
Leanne.
You may proceed.
Oh. For the jury's sake, may you please state your name?
My name is Leanne O'Neill.
What is your occupation, Miss O'Neill?
I'm a custodian here at the high school.
Now, prior to the case, did you know the Chases?
No.
May I ask when you heard about Mr. Chase's disappearance?
The first I heard of it was when I saw the news reports about the body being found.
What was your reaction when you came upon these reports?
I was shocked. Saugerties is a nice town. I wouldn't think anything like that would happen here.
May I ask you what you were doing the morning of July 26th, if you remember?
I don't really recall. I work a late shift, so probably what I usually do, which is waking up, doing errands around the house before I come into work.
When do you usually arrive at your shift?
My shift starts at 3, so I arrive a little bit before that.
And what time do you leave your shift?
Around 10 o'clock at night.
The night of the 26th, was there anything out of the ordinary at the school that night?
In the building, no, there wasn't. I just went about my job like I normally do, cleaning classrooms.
Now, you specified in the building. Was there anything outside the building to take account of?
I did notice activity in the garden.
What sort of activities would you describe these as?
I noticed someone dragging something into the garden and proceeding to bury it, but it was dark, so I couldn't quite see, but I did definitely see something that was out of the ordinary. It's not what I normally notice.
Now, may I ask where you viewed these events from?
I was in, I believe it was 211, it was a classroom in the 200 wing.
Does this room have a direct view of the gardens?
Yes.
Could you tell what the suspect was dragging?
No, I couldn't, but it was big and bulky.
Can you describe any characteristics about this suspect?
Tall, larger frame. It was hard to tell details because it was dark, but I assumed it wasn't a female just because of the size of the person and the bulk, I guess, of the person.
I believe that is all for now. Thank you.
Would the defense care for cross-examination?
May you please state your full legal name
Leanne O'Neill.
and what is your occupation?
I'm a custodian here at the high school.
So, what room were you, sorry, hold on, let me just get this straight. So, you saw the suspect during when they were trying to hide the body, correct?
Yes,
Can you describe any of their features?
not accurately, no.
Now, when you viewed the suspect, in your interrogation, you stated this: were you in room 211 in the 100 wing when you saw the suspect?
I was in room 211 when I saw the activity in the garden.
In the 100?
No, in the 200.
Your Honor, I'd like to introduce Exhibit A, which is video evidence of Mrs. O'Neill's interrogation process.
Is there any objection?
We may have some technical difficulties because we were unable to pull the video, but let's see if we can get it working.
All right, well, let's see.
I need Andrea for the video, so that we can either hold the proceeding until we can get the tech person here, or
So you're going to need a minute?
I'm gonna need a minute, yeah.
Yeah, okay.
There's-
That's fine, that's fine. So, Mr. Nacarado, I ask that you continue your cross-examination, and we will allow you an opportunity to come back to the video. Is that going to interrupt your cross-examination?
Yes.
So you need to have the video before you continue?
Yes.
Okay. And how long will it take for Andrea to get here?
Maybe 5 minutes.
How many?
5.
Okay. All right, so,
What's
why
time
don't
I
you-
was here to save the day?
Oh, I don't know about that yet.
if that microphone's not moving, you could have the question rest. So, disability, what do you do? What's interesting, used to come up now, classes in class.
It's not typing and,
It's not typing at all?
There are some things on sites in New York. There's different
And so what happens is,
different rules.
I know, I was working on it.
Like, in the Johnny Depp, they wrote how no, they tried that one. They're very
but we are under time restraints. I'm going to have you proceed with your cross-examination without the use of the video. You, of course, can refer to the video. You can question the witness regarding any prior statement that she made, but you'll have to proceed without the technical video. All right? Okay. So again, I don't mean to curtail your cross-examination in any way. You're just going to have to proceed without the actual video. All right?
Okay.
Okay.
Are you aware that in your interrogation, you contradicted yourself multiple times on your location in the building?
No, I'm not aware that I did.
So you believe that you were in room 211 in the school?
Yes.
When you had viewed the suspect carrying the body, had you seen two figures and had you seen lights?
I only saw one figure dragging something. sort of silhouetted in the dark, but that was all I saw.
Did you see any lights outside?
Not really. If there had been lights, I would have been able to get a better glimpse at what was going on, and I really couldn't tell.
Well, Your Honor, I'd like to introduce into evidence Exhibit B, which is another video.
All right. Can you define the other video other than the other, for instance, it's a statement, I assume?
It is the video of the presumed suspects dragging the body through the gardens at the night.
Is this a video that was taken, who took this video?
It is from the perspective of CCTV surveillance.
Okay, so it's taken by the school, it's video from the school?
Yes.
Okay. Do you have any objection?
Yes, sir. He mentions in this video there are multiple subjects. That does not match with our fact pattern.
Okay, so that's a fair comment. Would the video clear it up? Do you think you can play this video? One never knows. All right, I'll tell you what we're going to do. I'm going to ask you to continue. I note your objection. I'm not going to rule on it yet. Why don't you continue your cross-examination? If you cannot continue your cross-examination, I'm going to ask the witness to be available to recall, and we'll proceed with the next witness, and then you can ask Ms. O'Neill to come back, assuming that we can get all of this to work. Are you available for the next time?
Yes, I am.
Okay, so why don't we do you have anything else to cross-examine this witness on other than the two videos?
No.
All right, so I'm not going to afford a redirect examination right now. Why don't we ask Ms. O'Neill to step down and ask you to be able to be recalled when we get through our technical difficulties, which I thought I saw some oriental figures on there, so that can't be a good thing. So, okay, so why don't you have a seat, Mr. Navarro, and I'm going to ask Ms. O'Neill, and I'm going to ask the prosecution to call the next witness.
Thank you, Your Honor. We'd like to call Andrew Rappaport about the forensics team up.
Okay, and I'm going to ask you as well, when you address the court, would you stand, just as a courtesy? Thank you. All right, so you may call it, and what was the next witness?
We'd like to call Andrew Rappaport about the forensics team up.
Rappaport? Okay. Mr. Rappaport, is Mr. Rappaport here?
Not yet.
Not yet, okay. All right, so do we know the whereabouts of Mr. Rappaport?
Okay.
Okay, very good. All right. And so I'll tell you what, ladies and gentlemen of the jury, you've been here for just a few minutes, but it's probably a good time for us to step up and stretch. We're going to take a short recess to allow everyone to get organized, and then I'll ask you to come back in 5 minutes, all right? Just a quick stretch and come back in 5 minutes, all right? we're missing a couple of defense.
Yes.
Okay.
Here they come.
Probably shouldn't proceed without them.
Yes.
Apologies.
All right. All right, so I understand that at this point we have overcome technical difficulties. I'm going to ask Ms. O'Neill to return to the stand. And Mr. Nacarado, would you continue with your cross-examination? Ms. O'Neill, I'm going to remind you, you're still under oath.
Yes.
Okay.
So I would, of course, like to bring up Exhibit A, which is the O'Neill interrogation.
Okay, so when we took a break, you offered Exhibit A into evidence without objection, so I'm going to accept Exhibit A, which, just tell me what it is. It's a video of Ms. O'Neill? It's a video statement?
Yes, a video statement of Mrs. O'Neill done by an interrogation by the police.
Do you have the time when that was taken? The date, not the time?
The date is on the video.
Yes, it is.
Great, great. Okay, so we're going to accept Exhibit Defense, Exhibit A, the video statement of Ms. O'Neill in evidence. You may proceed.
Yes, and I would also like to bring up Exhibit B, which is...
Well, let's do it one at a time.
Okay.
Okay, and so you now have Exhibit A in evidence, and you can play it or use it however you would like.
I would like to play Exhibit A.
Starting at 1 minute, 20 seconds.
Yes.
And then skipping after a few seconds to 3 minutes, 20 seconds.
Okay, so please proceed. Excuse me one second. Can the ladies and gentlemen of the jury, can you see the screen? And so it's not, it is permissible if you cannot see or hear the screen to step up from your seats and get a little closer. It's important that you see it. It's just if you do leave your seats, please do not discuss anything about, don't say anything, don't discuss anything with your fellow jurors or any other people in the courtroom, all right? All right, you may proceed.
Okay. So I'd like to play the video from the timestamp of 1 minute.
What's your address? Washington Avenue Extension, Saugerties, New York.
Very sorry for the technical difficulties.
I was cleaning and I was in the 100 wing and I was cleaning up because it was a mess. There were other custodians, but they were in other parts of the building. I'm not really sure where they were. I was just, we don't always work together in teams. We kind of work on our own, so it was just me. You know, budget cuts. There's not as many of us as there used to be.
I had it. Rewind it to just before the timestamp.
Leanne and O'Neill.
3 minutes.
Who else was present? Oh, it was just me in room 211. I was by myself. There was nobody else with me. anyone
All right,
else
that's
have
good.
Vic?
As you can see, are you aware that you contradicted yourself by saying you were in the 100 wing and then later stated that you were in a room in the 200 wing?
I am now that I've seen the video. But I was nervous. It's nerve-wracking to be questioned. So I think nerves got to me.
So can you please say what room you were in?
211.
211, okay. I would now like to bring in Exhibit B.
Okay, and could you just move the mic up a little bit? I can hear you, I'm not sure everyone in the courtroom can hear you. Yes, okay, thanks. All right, so now, so Exhibit A is in evidence and it's been played for the jury, and you now are offering Exhibit B, which is an exhibit, purportedly a video taken by the school security system. Is that accurate?
Yes.
Okay. Is there any objection?
No, Your Honor.
No objection. All right, so defense Exhibit B, in evidence, without objection. Please proceed. Yes, please, yes.
From the timestamp, 3 minutes, 40 seconds onward. Double tap. Oh wait, no, my apologies, 4 minutes, 40 seconds. You see there a person moving through the field, and behind them a light, and the light turns.
Excuse me. So I would prefer that if Mr. Nacarado is examining this witness, that it'll get chaotic if we have different people in the courtroom speaking, even though you're defense counsel and you certainly are entitled to speak.
I'm very sorry.
That's okay. And if you need assistance, Mr. Nacarado, you can ask your co-counsel to come up and help you. That's fine. But I don't want to have a lot of random talking. It will get confusing. All right? Okay. So you may proceed.
As you can see in the video, we can see two people clearly identified by light. There's one person walking ahead carrying a flashlight, and another one being followed by a similar flashlight. From this, we can clearly infer that there were two people.
Okay. So do you have a question of this witness? Do you have a question for this witness?
Yes.
Okay, please proceed with any questions to the witness. And then the comments that you have about the exhibit that are in evidence can be made during the summation. All right?
Excuse me, Your Honor.
Yes.
Do you have an objection?
And what's your objection? And would you stand when you speak?
Yes.
Yes. And you know what we should do? We should move that book back so you don't trip.
Yes, I should. Thank you. Okay.
Okay.
Your Honor, our analytics expert, Sue Willig, has viewed said video. She declared that the timestamp is incorrect. The video took place at 9:30 on the 26th, and that there was only one suspect present in the video.
Okay. So you have, the exhibit is now in evidence. All right. So it is.
A clarifying statement for the jury, if that makes.
Okay, so the clarifying statements from all counsel should be made during the summation, and they should be made based upon the evidence that's presented. So it was my understanding that that witness may not testify. Is that accurate? All right. So if that witness doesn't testify, it wouldn't be permitted for counsel to testify.
Yes, Your Honor.
Based on things that you may know. But the jury is limited in making their decision based on the evidence that's presented to them here in the courtroom. All right. So if that alters what you plan to do as far as your trial work, so be it. But you are certainly, in the summation, you are both encouraged to discuss the evidence and your view of the evidence and what it shows. But you're not encouraged to offer testimony about things that took place outside of the courtroom.
I apologize.
No, that's okay. All right. Okay, so now, we left it off. You had a question for the witness.
Yes.
Okay. Please ask the question of the witness.
I would like to reiterate, how many figures did you see when you had viewed the body being dragged?
Only one.
And how many lights had you seen?
I didn't see any flashlights.
Are you sure?
Yes.
Thank you.
Okay, very well. Now, do you have any you may sit down. That, I don't know. That's okay. All right. Is there any redirect examination of this witness?
Yes, Your Honor. May I ask you, what wings in the school do you usually clean?
I usually clean the 200 wing.
Do you sometimes clean the 100 wing as well?
Sometimes if we're short-staffed, but most of the time it's just the 200 wing. There's enough classrooms there to keep me busy.
I believe that is all. Thank you.
Any re-cross-examination?
No, Your Honor.
Good answer. Okay. Thank you very much, Ms. O'Leary. You may step down. If you can. There it is. All right. Now, before we call our next witness, may I ask the prosecution, do you want that video to remain? Are you going to refer to the video in your next witness?
I want it.
Okay. So I would ask that the exhibit, can we clear the screen? Great. All right. And just for clarification to both counsel, those two videos are now in evidence. So in your address to the jury, in your summations, if you care to use the exhibits, you may do so. You may pull them up during your summations, you may point to them and try to interpret them in any way that you think is appropriate, all right? So they are in evidence. Okay, would the prosecution call your next witness, please?
Thank you, Your Honor. We'd like to call Andrew Rappaport of the forensics team up to the stand.
And is he with us now?
He is.
Excellent.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Mr. Rappaport, would you mind stating your name and occupation for the jury?
Andrew Rappaport, and I'm a member of the forensics team.
All right. And you can confirm that the body you found was indeed Douglas Chase?
Yes.
I'd like to bring Exhibit A for the prosecution to the stand. Exhibit C for the trial.
Okay, so technically, the defense are letters, so there are letters A, B, C, etc., and the prosecution will be numbers. So this will be your first exhibit, and we'll call that prosecution Exhibit 1. And what is prosecution Exhibit 1?
It is a document stating that they took DNA from the wife and the two sons of the deceased.
Do you have the document itself? Okay. Could you hand it to me, please? Thank you so much. Okay, so this is a document. We're going to call this prosecution Exhibit 1 for identification. Now, before you show it to the witness, would you show it to your adversaries so they'll know what exhibit you're referring to? All right, and now you may you may approach the witness and show him the exhibit and proceed.
This looks familiar to you, correct?
Yes.
Are you offering it into evidence?
Yes.
Okay, so the prosecution has offered exhibit number 1 in evidence. Is there any objection? Okay, so in evidence, no objection. And you may proceed. Do you need this back?
I,
Okay.
and you looked over both Gibson's house and the garden scene, correct?
Yes.
Did Mr. Gibson have any sorry, do you know which way the body could have been stabbed from?
He was stabbed 6 times in the ribs on the left side, and 2 other times on another front.
Thank you. And was there any blood found in Gibson's house?
Yes, that was.
Whose was it?
After DNA analysis, it was Blaine Gibson and Douglas Chase's blood mixed together.
Thank you.
I didn't hear the answer.
It was Blaine Gibson and Douglas Chase's blood mixed together
And where was that?
at the house scene.
Thank you.
May I proceed and bring Exhibit 2 to the stand?
Yes. What is exhibit 2?
Exhibit 2 would be the house, would be an overlook of the house.
Sure. Is it so it's a photograph or a diagram?
No, it's a document stating that there was blood at the house belonging to both Chase Gibson.
It's a report?
A report, yes.
Okay. Would you have it marked, or hand it to me and I can mark it either way? You have it marked? Okay, thank you. So now this is prosecution exhibit 2 for identification. Let me just see, it's marked. Okay, that's good. Would you show it to your adversary so they know what you're doing? All right. Now, are you offering this into evidence?
Aye.
All right, would you show it to, is this witness, the person going to explain it to us?
Are you just holding a copy of it?
It looks to be a report of the Blaine Gibson house scene.
Would it be accurate to surmise that, in fact, that you answered accurately to the questions of the document?
Yes.
Thank you.
You offering this into evidence? All right. And so we have prosecution exhibit 2 offered into evidence. Is there any objection? Okay. In evidence, without objection. Do you need this back?
No.
All right, you may proceed.
And was there a trash bag found at the garden scene?
Yes, that was.
Was it also found in Blaine Gibson's car?
At the same time.
And the knives that Blaine Gibson had were serrated, correct?
Yes.
Was there any stab wounds pertaining on Douglas Chase that were serrated?
All of the knife wounds were made by a serrated blade.
Thank you. And was there anything of Gibson's that could relate him to the scene?
I believe he had a business card.
And do the bones on the victim have any blunt force trauma? Maybe a punch?
Not that I could see.
Already. No further questions, Your Honor.
Thank you. Is there any you may sit down. Any cross-examination of this witness?
Yes.
Your Honor, may I approach the stand?
Yes, you may.
Please state your full legal name.
Andrew Rappaport.
And what is your profession?
I'm a forensic scientist.
Okay.
Victoria, could you pass that?
Mr. Rapp, Your Honor, may I present this piece of, or this object to the witness?
All right, so are you, what I would prefer is that you have it marked for identification.
Okay.
So why don't you hand that to me?
This is because, defense exhibit C.
Okay. And up here. Defendant exhibit C for identification. Right, now you may show that to you, if you don't mind, show it to your adversary so they know what you're doing, and then you can show it to the witness and have them identify it. All right? All right, please proceed.
Mr. Rappaport, do you recognize this object?
Yes,
Can you please identify it?
it was the plastic bag that the body was kept in.
And were you aware that there was a footprint left on the bag after it was recovered?
I have been made aware of that, yes.
Is it not a fact that that footprint was left by one of your forensics team members?
Yes.
Now, can you please explain the rules of handling evidence to the jury?
When handling evidence, you're supposed to keep a list of whoever handles it. You're supposed to be very delicate, use gloves, be very careful not to disturb it in any way.
Would you classify a footprint left by one of your members as disturbing the evidence?
Yes, I would.
Now, are there any members of your team that seem clumsy, careless, or otherwise unreliable?
There might be a few, but they are in the small minority.
But there are some.
Yes.
Is it possible, based on this, that your team might have made other mistakes while analyzing or recovering other bits of evidence?
Yes, some small mistakes might have been made.
I believe that is all. Thank you.
So are you offering exhibit C in evidence?
Yes, Your Honor.
Okay. So you have to do that. You have to say, I'd like to offer this into evidence. Is there any objection?
No objection.
All right. So could I have it for a moment? Thank you. Defendant's exhibit C in evidence. And do you want this back?
Yes.
Okay. Thank you. Okay. Any cross-examination?
I would like to, yes.
You may proceed.
I'd like to bring defense exhibit C to the stand.
Okay.
May I approach the witness?
Yes, and I misspoke. I meant redirect. I apologize. Thank you.
You can confirm that this is the same bag that was found in Blaine Gibson's car as used on the body?
It was the same type.
I have no further questions.
Thank you. Any cross-examination?
Yes, Your Honor. Your Honor, may I once again present this piece of evidence, or defense exhibit C, to the witness?
You may.
Now, Mr. Rappaport, you can confirm that it was the same bag?
Yes.
Okay. Is there anything unique about the type of bag that was found between, in Mr. Gibson's car or at the crime scene?
They are the same type, but it is a very common type of bag.
So nothing uniquely identified?
Nothing.
Okay, that will be all, Your Honor.
Thank you. You may step down, sir. Thank you. The prosecution call your next witness.
We would like to call Detective Ethan Kane to the stand.
Is Mr. Kane here?
No, Your Honor.
Okay, well, that will present a problem. Any idea when Mr. Kane will be here? 5 minutes. 5 minutes. All right, so the good news is, ladies and gentlemen of the jury, we need to have another brief recess. You've been at it for a little while. Why don't we reconvene around 5 up at 7 or 8 minutes? If you need to step out and use the loo or anything like that, do that. And then we'll all reconvene in 5 or 7 minutes, okay? Great. So when we took a break, we were about to call the third prosecution witness. Are you ready to proceed?
Yes.
Okay.
We would like to call to stand Detective Ethan Kane.
Excuse me, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
You may proceed.
Thank you, Your Honor. Okay. Please state your name,
I am Ethan Kane.
your occupation.
I am a detective for the police law enforcement.
May I ask if you remember as to your location on July 26th, 2023?
On that date, I was in the office working on recent cases.
May I ask if you were aware of Douglas Chase's missing persons case?
No, I was not aware at the time as I was focused on other things.
Do you know the date as to when the body was found?
No, I do not.
Were you at either of the crime scenes?
Yes, I was there to help with, setting up the crime scene and to investigate.
May I ask as to who your original suspects were for this murder?
I believe our original suspects were the wife, Ashley Chase. We also have Blaine Gibson as the other one, and I believe there was a third one, but I can't remember their name.
May I ask what made you suspect Mr. Gibson?
Well, we suspected Mr. Gibson they were business partners, and possibly there was a certain motive that could have, come with murdering the suspect, the person.
Did you interview Mr. Gibson yourself?
Yes, I did.
Was there anything suspicious about his line of questions and answers?
There wasn't multiple suspicions at the start, but once we deep dive into the interview, there were clearly some sort of suspicions that I held with my own and my partner.
Did you record said questions?
Yes.
Your Honor?
So the video's not in evidence yet.
May I submit?
So you'd like to offer into evidence a video?
Yes, Your Honor.
So we've had a couple of videos. Can we identify this as the video statement of the defendant?
Yes, this is one of the video statements of the defendant.
Okay. Can you identify it in any way, such as a date, or the first one, or the second one, or something like that?
This is the first of the interviews on November the 29th of 2023.
No, I'm sorry, November?
The 29th.
Okay. So there's been an offer into evidence, People's Exhibit 3, the video statement taken November 29th of the defendant, Mr. Gibson. Is there any objection? No objection? All right. So People's Exhibit 3 is in evidence without objection.
May I play it, Your Honor?
You may.
What was the time frame of you seeing them and then going to the city?
Well, the night before, we were at work talking about what needed to be done at the New York warehouse, and then after that, we said our goodbyes. I went to bed, and then I moved to New York.
Counselor, excuse me one moment. So, is the defendant, where is the defendant?
I think he went to the bathroom.
Under the circumstances, is there any objection to continuing, or should we wait? He has a right to be here, of course. Would you like us to wait?
Yes, Your Honor, I think it would be more appropriate for him to be here.
Well, I do too, actually. Okay, so, Ms. French, why don't you have a seat, and sir, just give us a minute, and then we will proceed. I'm sorry, I didn't notice that he wasn't here.
You want to go on?
Yeah, that's great. That would be, okay.
Appropriate for prosecution to proceed.
Okay. Somewhat out of the ordinary, but that's fine.
If I may, Your Honor?
All right, so, Ms. French, I think we left off that you were asking this witness about statements made on a video recording taken of the defendant.
Yes, Your Honor.
All right, may proceed.
I promise, so I made my double. Technical difficulties, again.
What was the time frame of you seeing blood and then going to the
Well, the night before, we were at work talking about what needed to be done at the New York warehouse. And then after that, we said our goodbyes. I went to bed, and then I flew to New York.
And at what time during the trip did you find out that
It was actually while I was at the Sotheby's auction house. I found out, I got the message, and I dropped what I was doing and came back.
Thank you, Your Honor. Should we all? Detective, you can attest to the fact that that was Mr. Gibson?
That was in fact Mr. Gibson on that interview.
Now, Your Honor, I would like to offer into evidence Exhibit 4.
Okay, and what is Exhibit 4?
A map of the cell phone pings of Mr. Blaine Gibson on the day of July 26th.
So it's a paper document?
Yes, Your Honor.
All right, could you show it to me? Thank you. So this is Prosecution Exhibit 4 for identification. Would you show your adversary?
Yes, Your Honor.
All right, are you offering it into evidence?
Yes, Your Honor.
Okay, is there any objection?
No objection.
No objection. Prosecution Exhibit 4 in evidence. You may proceed.
May I approach the witness?
Yes, you may.
Can you identify this map?
Yes, I can.
What does this map display?
Well, it seems here that this map does in fact display cell phone pings that are around mostly, it varies from the area, mostly Saugerties and Kingston.
And can you vouch that in the video, Mr. Gibson stated that he was in New York City on the day of the 26th?
It was in fact in the video that Blaine Gibson did in fact say that he was in New York.
And does this map of his location match that statement?
It seems here that, yes, it most likely will line up with his statement.
The statement that he was in New York City, when on the map you stated that he was in Saugerties, New York?
I'm very sorry. No, it does not line up with the statement. In fact, my apologies, that was my mistake. No, it does not line up with the statement.
So you're stating that he possibly lied about his whereabouts?
Yes, that is true.
Thank you.
Thank you.
Mr. Kane, were you aware that on the day of the 26th, there was a seminar in Saugerties?
Yes, we learned about the seminar through interviews.
And, may I ask, did you... Oh. Your Honor, I would like to submit or offer into evidence Exhibit 5 of the prosecution.
And what is Exhibit 5?
The secondary interview of Mr. Gibson.
All right. Before you play Exhibit 5, is there any objection?
No.
All right, so Exhibit 5 is the second interview.
So this is we looked into Mr. Chase and why he seemed to be looking into a cyber solution company.
Okay.
With Sasha Benson. They had a seminar Wednesday of the 26th at 3 p.m.
Okay.
And we have you on the attendance sheet with Mr. Chase.
you know, sometimes you don't want to tell everyone what you're doing, so you have someone else write your name in so that you can get credit for that, for, you know, like taxes and stuff like that. So I had him write my name in, and I was in New York.
Okay. I would like to submit that into evidence, Your Honor.
All right, so Exhibit 5, the second interview of Mr. Gibson is in evidence without objection.
So, to clarify, Mr. Gibson restates that he is in New York City, but I would like to offer into evidence the attendance sheet that says that he was at the seminar.
So do you have the attendance sheet?
Yes, Your Honor.
Objection, Your Honor.
One thing at a time. I know your objection. Could you show me the attendance sheet? Okay, thank you. So this is the prosecution exhibit 6 for identification, purportedly a seminar attendance sheet. Would you show it to your adversary?
Yes, Your Honor.
And you're offering that into evidence?
Yes, Your Honor.
Is there any objection?
No.
There's no objection, okay? Exhibit 6. Excuse me.
There is, however, Your Honor, an objection to the prior piece of evidence.
Okay.
I apologize. That's something that came up after watching the video.
Okay, let's do one thing at a time. Do you have any objection to Exhibit 6?
No.
All right, so Exhibit 6 is in evidence without objection. Counselor, do you want this back?
Yes, Your Honor.
All right, so you take that. Now, before you proceed, we have a perhaps an untimely objection to, that's okay, to Exhibit 5. Is that correct?
Yes.
Okay, would you stand when you speak? Thank you. All those book bags were probably so you don't
During the video, during the same timestamp that we watched, apologies, the plaintiff stated that Mr. Gibson claimed that he was in New York City. However, he only stated that he was in New York, which Saugerties is in New York. So that lines up with his statement of the cell phone tracking.
Okay, so we sometimes get confused with our verbiage. When you say plaintiff, who are you referring to, the defendant?
No, sorry, the prosecution.
Okay, so the prosecution witness, are you saying? Who?
Yeah.
Okay.
So the prosecution presented their video in which the defendant stated that he was in New York. The prosecution claimed that he said he was in New York City when he did not specifically say that.
Okay, so what I would, I'm going to overrule your objection. The exhibit is in evidence. Certainly your observation is one that might be made in your summation to the jury. Right, so that would be, not suggesting it's not an appropriate observation, but the time to do that, the time to address the jury is during your summation.
Okay.
Is that fair?
Yes.
Okay, great.
All right, thank you, Your Honor.
All right, so back on track. The prosecution exhibits 5 and 6 are in evidence. You may proceed.
May I approach the witness?
You may, thank you.
Okay. Detective, can you identify this document?
This document is the seminar attendance sheet.
And can you confirm if Douglas Chase and Mr. Gibson's names are on there?
Yes, I can confirm that both names are on the attendance sheet.
This lines up with your statement in the video of having someone sign him into said seminar?
Yes.
Thank you.
Thank you.
Now, we can confirm, though, that Mr. Gibson said he was not at the seminar?
Yes, I can confirm that he did in fact say that he was not at the seminar, though his name appeared on the sheet.
Thank you. Oh, I would also like to ask you if you ran background checks on the attendees of the seminar.
We ran background checks on the ones that seemed most needed for background checks, but the rest are clear.
Back to my prior questions, if you even remember them. You said you were at both crime scenes.
Yes, that is true.
Now, can you attest if there was any damage to the crime scenes that was seen, possibly before or after any teams had showed up for investigation?
When we first arrived, there was no prior damage to any of the scenes that we came up with, and I believe that we did not create any damage while investigating.
May I ask you about any missing objects that might have happened to stand out at either of the scenes?
I would not have any knowledge of that because I was not the one who was in charge of that.
Thank you. I believe that is all, Your Honor. Thank you.
Does the prosecution care to cross-examine? Excuse me. Would the defense care to cross-examine?
Yes, Your Honor.
Right. Please proceed.
Please state your full legal name
I am Ethan Kane.
and your occupation.
I'm a detective for the law enforcement.
So you were investigating both crime scenes, correct?
That is correct.
Did you investigate Mr. Blaine Gibson's house?
Yes.
Did you notice the knife set in his house?
No, I did not notice the knife set in his house, although I remember hearing a conversation about it.
Did you hear about any amount of knives that were in the knife set? How many that might have been missing?
I believe there was one knife missing from the full set.
Your Honor, I would like to introduce Defense Exhibit D.
And what might that be?
It is a picture of Mr. Blaine Gibson's knife set.
Is it marked? I can do that. Okay. So we have defendant exhibit, where are we at, D, for identification. Right. Would you show it to your adversary?
May I approach the witness with
You may.
Test. Can you identify what this is?
It is a knife set.
Do you know where it might have been from?
I believe it was in Blaine Gibson's house at the time.
Can you identify how many knives were missing?
It seems here in the picture that 2 knives are missing from the set.
In your prior statements, do you mention that only 1 knife was missing?
That is correct.
Thank you.
So are you offering this into evidence? Is there any objection?
No, Your Honor.
All right. So defendant exhibit D is in evidence. No objection. You need this back?
I would like to also call into Exhibit E.
Okay, and what is Exhibit E?
It is, oh wait, that's already. Oh, sorry, I had misspoke. I would like to call into evidence prosecution exhibit, I believe, 4. Oh, 2. Very sorry.
Okay, so you would like to see Exhibit 2?
Yes, please.
Okay, here it is. Oh, no, it's in evidence. You may proceed. I don't know what you're intending to do with it, but it's in evidence. You may use it to cross-examine the witness, or however you want to proceed.
I approach the witness.
You may.
Could you please read in the forensic segment number 3?
Number 3, forensics. Knives of the knife set were studied for blood traces. None were found. Knives are all finely serrated with a left bevel.
May I please receive the evidence? Sorry, I may have chosen the wrong pen. Sorry, okay. So, in the image that was previously shown to you, the exhibit, Exhibit E, I should be on that. How many knives were missing from the set?
From the document, 2 knives were missing from the set.
How many knives did you state were missing?
I believe I stated that only 1 knife was missing.
So, is it possible that a knife was found but was failed to be reported?
That could be correct.
Thank you. Your Honor, I would like to call into exhibit. Would I be able to exhibit 2 pieces of evidence, please?
These are exhibits that are in evidence?
One is in evidence and one will be newly introduced.
Okay, so let me suggest that if you're going to refer to an exhibit that's not in evidence, let's get that in evidence.
Understood.
And then you can do what you would like to with the exhibits.
I would like to introduce defense exhibit E.
And what is defendant's exhibit E?
It is satellite mapping of cell servers for Mrs. Ashley Chase.
Okay, defendant's exhibit E for identification. Would you show it to your adversary, please?
May I approach the witness?
Yes, you may.
Can you identify what this is?
This is a map showing also cell phone pings for Miss Ashley Chase.
While observing the map, can you pinpoint any exact location where cell data may have got mapped?
No, I cannot pinpoint on the map any time locations were lost or...
May I please take the exhibit? Thank you. Now, I'm not sure, but I'm going to try and win this here, but if we look right here, we can see a red ping, which, if we refer to the guide up here, we can see refers to lost cell data in this specific area.
My correction, I did not see that as it was very tiny, but yes, I do see that now.
Yes, very sorry.
It was one location.
Understood. Thank you.
Are you offering this into evidence?
Yes.
All right. Is there any objection?
Yes, Your Honor.
Okay, what's your objection?
The red ping has no other orange ping to back up, meaning there was no way the cell phone could turn on, and since the red ping isn't occupied by time, it can only be surmised that that red ping would be a mistake.
All right. Do you have any other objection?
No, Your Honor.
So I'm going to, you're offering this?
Yes.
I'm going to allow Exhibit E into evidence over your objection, and I would observe that those comments are, see, in this setting, we don't have anyone from AT&T here to explain what you've just said. So what I'm going to recommend you do is when the defense is finished with this witness, why don't you address the witness and try and get the information you're looking for through the witness. Right? But the objection is overruled as far as the exhibit. So defendant's Exhibit E is in evidence. Do you need it back?
No.
Okay.
I would also like to call upon prosecution exhibit, I believe, 4. It should be a similar AT&T satellite map.
Okay, it's right here.
Can you identify what this is?
It is the cell phone ping AT&T map
For?
for Blaine Gibson, I believe.
Can you identify any spots where the cell phone signal may have died out?
At 8 p.m., I see that the cell phone had died out right there.
Can you confirm that this was in a similar area that was presented in Exhibit E?
I can confirm that both locations are very close together or identical.
Can we confirm that this could possibly be a cell dead zone where there lacks any cell service?
That is possible, I believe.
Thank you. One more question. Are you aware of the date that Mr. Gibson had left for New York City?
I do in fact know that he left for New York, but I do not know the date and time.
It was July 28th. Those AT&T data maps, could you infer what date they were taken? Sorry.
Both maps, the date and time that were taken was both on July 26, 2023.
Thank you. That will be all.
Okay, goes to bench. Any redirect examination?
Yes, Your Honor. May I also call map exhibit 4 from the prosecution?
That both of them there.
Looking at this map from Ashley Chase, correct?
Yes, you are correct.
Can you state the time that she was in the town of Saugerties?
She was in the town of Saugerties from 1 to 3:30 p.m.
Thank you. May you state when Blaine Gibson was in the town of Saugerties?
Blaine Gibson was in the town of Saugerties 5 to 7:30 p.m.
Well, are there any other times he was around the town of Saugerties?
There was... No, I don't believe so.
Are there any times that he was around the scene of the garden?
Yes, yes.
Can you state the times that were?
I believe the times are 8 p.m. to, yeah, just 8 p.m.
Thank you. With this statement, we can see, in reference to Ms. O'Neill's statements about the suspect seen around late on the 26th, that Mr. Blaine Gibson was around the scene of our crime at the time of Ms. O'Neill's sightings, whereas Ms. Ashley Chase was nowhere near our scene at all.
So, Counselor,
Yes.
did you have a question for this witness?
Yes, I
Okay.
Yeah.
So I would caution that counsel for both sides should try to refrain from making comments regarding your opinions of the evidence until the time of summation. The appropriate time when you address the jury to say, we think, and this exhibit shows, that kind of thing. But technically, counsel are not, you're not allowed to opine and offer testimony. The testimony has to come from a witness or an exhibit. But your comments are welcome at the time. This witness any question you like, but you may not offer testimony of your own.
Yes, Your Honor. Thank you.
All right.
I would like to call in from evidence prosecution exhibit number 1.
Okay, so here is your exhibit number 1.
And may I also call exhibit D from the defense?
Okay, that's 1. D, and this is D.
Now earlier, you identified these as serrated blades, correct, belonging to Mr. Gibson?
That is correct.
Yes, thank you.
What do you, all of the exhibits are in evidence.
May I speak to my counsel for a moment?
Sure.
May I offer into evidence exhibit 7 of the prosecution?
And what is exhibit 7?
It is a forensic description of the body.
All right.
I'm getting there.
Is it a report, a document?
Yes.
Okay, and so has it been marked as exhibit 7?
No, Your Honor.
Okay. Thank you. So, prosecution, exhibit 7 for identification. Would you show it to your adversary, please? And you want to, yes, go ahead.
Again, who did this next set belong to?
Blaine Gibson.
And you admit that there were knives missing from the set?
Yes, there were two knives missing from the set.
Now, can you please read the final line under findings of this forensic report?
The final line?
Under
Okay. Puncture marks on bone suggest a finely serrated blade with a left bevel.
Do these match the specs of Mr. Gibson's knives?
I believe they do.
Thank you.
So are you offering exhibit 7 in evidence?
Yes, please.
Is there any objection?
No objection, Your Honor.
Okay. All right. People's Exhibit 7, the report autopsy or medical examiner is in evidence.
That is all, Your Honor. Thank you.
All right. So would you care to have any re-cross-examination?
Yes, Your Honor.
Please proceed.
You had managed the interrogation of Blaine Gibson, correct?
The first interview on Blaine Gibson, yes, I was there.
Did you manage or were a part of the investigation on Mr. Blaine Gibson's house?
Yes, I was there.
Why was only Blaine Gibson investigated? Is there any particular reason?
Because at the time we had reasonable suspicion against Blaine Gibson, but I do not know the reason behind the reasonable suspicion.
Is there any reason why you did not that you did not search the houses of any of the other interrogatees?
Because at the time we did not feel that they were as suspicious as Blaine Gibson seemed to us at the time.
But could it be possible that possibly some of these other suspects could have held any sort of evidence significant to the case?
It could very well much be possible, and it could possibly be at fault for us not looking into the other ones.
Could I please call upon Defense Exhibit D again? Can you identify what this is?
This is, again, the knife set that belongs to Blaine Gibson.
Is there anything special or significant other than the missing knives from the knife set that would distinguish this knife set as Mr. Gibson's?
No, there is no distinguishing features that could possibly relate this knife set to Blaine Gibson.
Would you admit that it could be more of a common store-bought knife set?
Yes, that is correct.
Thank you. May I please speak to my co-counsel temporarily? Now, if this was a common knife set that you would be able to obtain from the store, would it be possible that anyone could have obtained these knives?
Yes, it would be possible.
And anyone could have used these knives as the murder weapon, correct?
That is true. Anyone who is in the vicinity of the knife set could easily grab a knife from the set.
Thank you. That's all.
Anything further of this witness?
Yes, Your Honor.
I'd like to call prosecution exhibit 7 up. Thank you. On this document, does it say that the stab wounds on Douglas Chase were made with a serrated knife?
It does say that the marks were suggested a finely serrated blade.
And you can agree that the knives found in Gibson's house were serrated?
Yes, that is correct.
And did they all have left bevels as stated in the document?
Yes, that is correct.
Thank you. And I'd also like to call the two maps up to the stand.
Sure.
on these two maps, if you can state that Ashley Chase was nowhere near the school or the town even at the time of 8 to 10 p.m.
Yes, that is true.
And it's also true that Gibson's phone was turned off at 8 p.m.
Yes, that is true.
Was Ashley Chase's phone ever turned off?
Yes, her phone was turned off once, I believe.
And was it ever turned back on during that night?
No, I don't believe so.
All right. Thank you. No further questions, Your Honor.
Anything else?
Yes. Sorry, I think the defense record was up here, and I returned it to them.
You may.
You didn't want to look at it.
May I please call upon Defense Exhibit D, please? Thank you. Now, like we have previously stated, can you agree that this knife set may have been a common store-bought knife set?
Yes, that is correct.
And would it be possible that this common store-bought knife set would be able to have the matching left bezel serrated edge?
That is correct.
And would it be possible that pretty much, again, anyone who would have owned this knife set would be able to obtain the murder weapon and be able to, well, commit murder?
That is correct. If they had the same knife set, that is possible.
Thank you. Would I be able to call up evidence from up here? Would I be able to call up more evidence from up here?
Yeah, whatever, all the evidence, anything that's in evidence is available to any counsel. The only reason it's kept at the desk is to try and keep track of it. So anything you need, you just ask for it and you have it.
Could I call into question Defense Exhibit E? That would be the satellite map of Ashley Chase. Thank you. In this satellite map, can you notice that Ashley Chase was in the school at any odd hours, such as during the night?
No, the hours are normal for school.
May I please examine the evidence? That should be all. Thank you.
Thank you. Anything else?
No, nothing.
Anything further of this witness?
One last thing. May I bring up prosecution exhibit 2?
Exhibit which?
2.
I think 2 might be on the defendant's desk.
Thank you. You investigated the scene at Mr. Gibson's house,
That is correct.
and may you examine this paper for me? Does this paper indicate that any sort of violence might have been committed at Mr. Gibson's residence?
There was a large amount of blood traces using luminol that were found in the suspect's kitchen.
May I ask whose blood was reported that to be?
through reading in the forensics, the blood evidence was determined to be a combination of both Blaine Gibson and Douglas Chase's blood.
So, to get this straight, wounds were inflicted in this scene.
That is correct.
Thank you, that's all.
Thank you. Anything further? All right. Could I have both counsel approach the bench, please? Why don't you all come up? All right. She's not going to join us. You're going to join us? And the lieutenant may join us as well if you'd like. It's not complicated. Okay. A couple of housekeeping things before the rest. Number one, I gather you have other things that you need to do from time to time.
Only one more thing, it's shepherd the students of the School of the Arts.
So is there any objection to waiving the defendant's appearance if he needs to step out? Okay, I certainly don't have any objection under these circumstances. So
We'll only do one more time, Your Honor.
It's quite all right. I'll leave it up to you whether counsel, whether you want you here or not. Sometimes it's helpful to have a defendant say, did you really say that? Or something like that. So you folks decide that. I will not have any. If you don't have any objection, I assume the circumstances go. Okay. Item A. Item B. Just as far as procedure is concerned, it's a little, and we didn't go over this, it's a little awkward using the alcohol of evidence. All the evidence is in, anything that's in evidence, evidence. But you have to understand the IC. I'm only keeping it here on the bench, as I said, to try to see that it doesn't wander off or something like that. Okay. Well, you'd be surprised how often they can slip into notebooks. Now, I'm assuming that you would like to recall a witness to this case. Well, I believe I'm the judge, and I believe I'm making that decision. All right, so do you have an application to recall a witness to this case?
Yes, we would like to recall witness meeting.
All right, and is Ms. O'Neill available? Right. So it's probably a pretty good time to take a break. It is not out of the ordinary to recall a witness before you rest. There would be a problem if you rested and then you want to call a witness. All right. And so even if there is an objection, I'm going to overrule that objection. I don't know if there's an objection, but I would allow you to recall Ms. O'Neill, assuming that she's available. Okay. Delay the trial for a day or two to bring her back. So, all right, you may go back to the benches. All right, so there's an application before the court. There's an application before the court to recall a witness, and by the prosecution before the prosecution rests. I've granted that application depending on the witness's availability, of course. This would be a great time to take a break. I think we anticipate lunch at about 10:30. Yay. So let's take a break right now, a good 10-minute break. That'll bring us back to 10 o'clock. So you're all free to get up. Ladies and gentlemen of the jury, I just would mention, I should have mentioned before, during these recesses, I'd ask you not to discuss the case amongst each other. Right? So your deliberation should only take place in the deliberation room. So as you wander about wherever you're going to do the next 10 minutes, please do not discuss anything about the case. All right? All right, so we'll take a 10-minute recess.
Call upon any video?
I'll wait till the last one.
All right, we're going to reconvene the case at this point, and the prosecution has an application to recall a witness.
We would like to call the stand Leanne O'Neill.
Ms. O'Neill? Ms. O'Neill, I'd like to remind you that you are still going to vote.
Yes.
You may proceed.
If it may please the court, please state your name.
Leanne O'Neill.
Thank you. And may you again describe the night of July 26th?
I came to work like I normally do. Started cleaning the classrooms, and when I got down to room 211, I took a little bit of break and I sat down at one of the desks and just kind of sitting because I've been cleaning pretty hard, and I happened to look out the window, and that's when I saw what looked like a very tall man, I'm assuming man, a tall figure, dragging something through the garden. I couldn't quite tell what they were dragging. I couldn't quite tell what they were struggling with, but it was dark and it was hard to see, but it caught my attention because it was unusual to see something like that.
You say that it was dark. Could you perhaps tell us what time this was at?
It's probably around, somewhere probably between 9:30 and 10 o'clock. I don't remember exactly what time.
Thank you. I would like to call in, or no, may I please see Defense Exhibit E? Thank you. If you would look at this, please.
Sure.
It should be stated there in red. Do you know what this document is?
It looks like, I guess, phone records or something like that, like where a phone was at a certain time, just because I see AT&T in the corner.
Mm-hmm. And can you locate where the school is on that map?
Yes. Yes, more or less, yes.
On the first map there. Can you tell us what times are listed around the area of the school?
If I'm looking correctly, probably like, I don't know, there's one time near the Arts Arena that says 8 p.m., but then others that say 5 to 7:30, and that I think is probably more in the village, so I think probably 8 p.m.
Are there any other numbers around where the school is?
There's one a little bit further away, but it says 10 p.m. near the intersection of where 212 would go over, it looks like the thruway.
And would you say this was around possibly the time that you saw what you did see the night of the 26th?
Yes.
Yes, thank you. Thank you, ma'am.
You're welcome.
May I speak to my counsel?
You may.
I think that would be all, Your Honor. Thank you.
So before defense, I just want to clarify, you had two exhibits before the witness.
The witness was looking at exhibit from the prosecution.
Exhibit 4 from the prosecution.
Yes.
The one that she identified, the 2 times on that you.
Yes, Your Honor.
asked about. Okay. And for my edification, this phone record is, whose phone is this?
That is the phone records of Mr. Blaine Gibson.
All right, and so the document indicates customer number, et cetera, and this is Blaine Gibson's cell phone number.
The defendant, yes.
Okay. Counsel, do you have any objection if I mark this exhibit as Gibson? Okay. Give me one moment. Gibson. All right, and now I have another phone document here that does indicate customer name Ashley Chase.
Yes, Your Honor.
Okay. The old one just didn't have to have a name on it, so we put Gibson on that. Is that all right?
Yes, sir.
Okay, you may, honestly,
Thank
you
you.
want to address your counsel? So, are you done?
Yes, Your Honor.
Okay. Any cross-examination of this witness?
No, Your Honor.
Thank you. Thank you, Ms. O'Neill. You may step down.
Thank you.
You can do so without letting yourself out. Okay. All right, now, do you have any other witnesses or exhibits?
No, Your Honor.
And so the prosecution rests?
Yes, we do.
Before we take, so we're going to take a break, but before we take a break, does the defense have any application to the court?
No, Your Honor.
Okay, very well. So just because we have lunch coming and we didn't want to, I didn't hear it?
10 minutes lunch will be here, so we're going to start to get everything out.
So we're going to take a break now. All right, so we're going to take a break. It'll be a long break. We're going to have some lunch, get the defense ready to get tuned up for their case. And then after lunch, we will proceed with the defense case.
At 11 o'clock.
11 o'clock, all right. So we're going to take a break now until 11 o'clock. So again, ladies and gentlemen of the jury, I admonish you not to discuss the case amongst yourself or with anyone else while we're on this break. All right? Okay, thank you.
Your Honor, it should be noted that a bunch of the jury has already made up their minds.
What?
Three of them have come to me accusing me themselves.
Your Honor, I think we should put in the alternates.
Yup, every single one.
3 people said it, we didn't replace those 3 people.
Look, that could be Mary's pollution. Mary's pollution now.
That won't look good on your track record.
No, it won't. I've got a wife and pollution.
Better not leave that around, they can use that against us. They got DNA.
Your Honor.
I don't know if it's a sweet case, they might accept that.
We're just waiting for a witness, so it will be just a minute. Oh, good. We all set? All right. So we're going to reconvene. This is the case of the state of New York against Blaine Gibson. And the people have rested. Is the jury present? Jury, okay. So the defense may call their first witness. The defense.
Defense would like to call upon Mr. Cooper.
Okay, would you stand when you address the court, please?
Yes.
Okay. Mr. Cooper?
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Can you please state your full legal name?
Michael Cooper,
And what is your occupation?
teacher.
Okay. So you found the body, correct?
I did.
Can you tell us the story?
Yeah, we were digging in the garden. We were taking a soil sample, going down, measuring horizons, and we hit something hard. And so we started excavating it, trying to figure out what it was, and then it turned out, unfortunately, it was a body.
How were you able to identify this as a body?
As a human?
Yes.
Well, in the field, it was a best guess, but the true identifying factor, what we first came across, was the femur. And so when you look at a human femur, it's significantly longer than other bones of the human body, whereas most animals around here, most quadrupeds, it's not. So that was our first guess.
Would you consider yourself tall?
Average.
Average? Maybe a little bit above average?
You're talking about your height now.
Sure. Yes.
Do you ever go into the garden alone?
Sure.
I'm very sorry. When?
You mean during the day or throughout the year or
Just generally throughout the day.
throughout the day? Yeah, we're in there several periods throughout the day, during a school day. I'm usually in there before school starts, and then sometimes even after school ends.
Do you work nights?
No.
And do you know Mrs. Ashley Chase?
No.
Okay. May I please convene with my co-counsel?
Sure.
Judge, can I speak to you for a moment?
You'd like to approach the bench?
Yes.
Sure. I'd like to have opposing counsel come up as well, please.
Your Honor, that should be all.
Okay, thank you. Any cross-examination? Yes, Your Honor. Oh, yes, sorry.
Mr. Cooper, did regular people have access to the garden?
Sure, yes.
Was it open during during summer?
Yes.
And who found the body exactly?
Students digging in the garden, 2 students did.
And they came to you, and then you reported it to the police, correct?
Correct.
All right. And what was the condition of the body when it was found?
How so?
Like, it was in a bag, correct?
Correct.
And did you see any part of the body?
Well, to some extent we did in order to be able to identify it as human, we did, but no, we didn't exhume the body, no.
All right. And I'd like to ask this about your education. You're a biology teacher, correct?
Correct.
And what degree do you have in biology?
I have a undergrad, I have a bachelor's degree in environmental forest biology.
So you'd be pretty knowledgeable about the human body, correct?
For the most part, yes.
And you also stated previously that you had your students look over the garden as well as you did during school hours, correct?
Correct.
Is there any reason why your students would be in the garden over the summer?
It's open to them for whatever reason. Some choose to come in and still take care of their beds over the summer, so sure.
Alrighty. I believe that's all of my questions.
Thank you. Any redirect?
No, Your Honor.
Thank you, Mr. Cooper.
Thank you.
The defense may call their next witness.
We would like to call Miss Vivian Jackson to the stand.
Ms. Jackson?
She'll be here momentarily.
Okay.
Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth?
Your Honor, may I approach the stand?
Yes.
Can you please state your full and legal name?
Vivian Jackson.
And what is your profession?
Right now, I'm a math educator.
And so, where were you on July 26th, 2023?
At the Flanders Hotel in Ocean City, New Jersey.
And from my understanding, you were there with your late husband, am I correct?
Correct.
Now, if you don't mind my asking, how long ago did your husband pass away?
November of last year.
And how was your marriage with him prior to his death?
Fine.
And what was your relationship to Mr. Chase prior to his death?
I was his employee.
Now, from our understanding, Mr. Chase's wife, Miss Ashley Chase, suspects you of having been in an affair with her husband. What reason might she have to believe this?
I really have no idea.
And so you had stated that you were the secretary of Mr. Chase and Mr. Gibson, yes?
Correct.
And so during the COVID-19 pandemic, when Mr. Chase was unable to work, how was the business affected?
Like any business, I think it was devalued.
And has it been affected in the same way since Mr. Chase's unfortunate death?
I believe so.
Okay. I believe that is all we have for you, Ms. Benson. Thank you.
Any cross-examination?
Yes, sir. Ms. Jackson, may I ask you how long you worked at the art company for?
About 5 years.
What hours would you usually work at the company?
I would usually work into the evenings. We had West Coast clients.
Now, how often would you speak with either of your employers?
Not very often with a dependent, but from time to time with Mr. Chase.
Did you ever see Mr. Chase and the defendant interacting often?
No, not really.
May I ask how often either of them were in the office?
One was in the office a lot more than the other.
May I ask who this one was?
Mr. Chase.
Was Gibson often out of the office for work-related reasons?
I really don't know where he was, but he wasn't there a lot.
Did this affect how much work was getting done in the office?
I sure think so.
Did that weigh negatively on Mr. Chase?
Yeah, one time he said that maybe he was thinking about doing something else, getting another job.
Before his death, did Mr. Chase ever seem out of sorts?
I really only remember that one time when he seemed discouraged and was thinking about leaving.
Did he ever mention his home life while he was?
Not really to me.
Would he ever appear at work with injuries?
Not that I saw.
Did he ever confide in you with his interactions with other employees?
No.
And may I ask how business was going before you left?
I think it was starting to get better.
Would you say it was turning a profit?
I really don't know the details.
May I ask when you stopped working?
At the end of July,
What led to this?
I was laid off.
Were there other people laid off around the same time?
I really don't know.
Your Honor, may I approach my counsel?
Yes.
Before, you mentioned that Mr. Gibson was often out of the office, correct?
Yes.
Did it seem like he was still getting work done while he was out of the office?
I really don't know, but not as many things that came across my desk from him.
Now, you mentioned that Mr. Chase would work much more often than Mr. Gibson, correct?
Correct.
And would you argue Now, sorry. Would you say that Mr. Chase was perhaps the backbone of the business?
Yes.
Whenever he might have been out sick or for any other reason, would you say the business had suffered?
Maybe.
I believe that is all.
Any redirect? No, Your Honor.
Thank you, Mr. Does the defense have any other witnesses?
Yes. We would like to call Miss Ashley Chase to the stand.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
You can hear the answer if you say yes.
I do.
Please state your full legal name for the record.
Ashley Chase.
And what is your profession?
I'm a teacher.
Now, where were you July 26th, 2023?
Well, I was home in the beginning of the day.
Excuse me, Ms. Chase, could you put that microphone a little closer? Sure. Thank you so much. And try to keep your voice up so all of us can hear.
Okay. I was home in the morning, and then in the afternoon I met a colleague, friend for coffee, and then I went grocery shopping, and that was it.
Okay. What colleague did you meet with for coffee?
I think it was Mrs. Ortley.
And in your profession, do you know a Mr. Cooper?
I do.
Now, if you don't mind me asking, what was your relationship to your husband, Mr. Douglas Chase, before he died?
Well, we were married, and it was okay. We got along decently well most of the time. There was some friction the past few months before his disappearance, but it was okay. Most of the time, he wasn't home, so.
And did you feel like this put a lot of strain on your family life?
It did. I had to take care of our children, my child, and our friend's child that is always at my house. So I was basically feeling like a single mother most of the time.
Okay. And so, as we have previously stated, it seems that you believed Mr. Chase's secretary, Miss Vivian Jackson, of having been in an affair with him.
I did.
Do you have any proof of this?
I don't.
So it's purely speculation?
I guess.
Okay. At this time, Your Honor, I would like to present Defense Exhibit F.
And what is that?
This is a document detailing Mr. Douglas Chase's life insurance prior to his death.
Defendant's Exhibit F for identification. Please show it to your adversary before you proceed.
Now, Ms. Chase, can you please identify that document?
It's a life insurance policy.
Of whom?
My husband.
And can you please state the value of the life insurance?
$1 million.
And were you aware of this prior to your husband's death?
I knew that we had an insurance policy, but I did not know the amount.
Were you aware that you were the only beneficiary?
Yes.
All right. I think that's all we have. So thank you very much, Ms. Chase.
Counselor, are you offering this into evidence?
Yes.
Is there any objection?
No objections.
Defendant's Exhibit F in evidence. Excuse me. No objection. Do you care to cross-examine the witness?
You're right.
Ms. Chase, do you mind stating your name and occupation?
Ashley Chase, teacher.
And where did you work as a teacher?
Saugerties High School.
And how long did you know Mr. Chase before you guys got married?
Before we got married,
Yes.
probably about 4 years.
Do you know the time around when you met first?
Probably about 11 years ago.
All right. And were you aware of Mr. Gibson and Mr. Chase's business from the start when they first wanted to open it?
I did know.
And can you tell me where you were around the July 26th?
I was home, and then in the afternoon I met a colleague for coffee, and then I went grocery shopping, and that was it.
All right. And can you tell me where your kids were during that time?
My youngest child was with my mom, and the other child was with friends.
Okay. And you stated that you were aware of your husband's life policy, but you weren't aware of how much it exactly was, correct?
Yes, I believe it changed.
And can I see evidence F, or Exhibit F for the defense? Thank you. You may approach the witness.
You may.
And are you aware that this document isn't signed by? Are you aware this document isn't signed?
No.
The signature on the document isn't signed, correct?
Oh, correct.
So wouldn't that entail make the whole life insurance policy invalid?
I really have no idea how it works.
Okay.
Thank you.
And you said it was you that reported the missing, correct?
Correct.
And can you tell me how that morning went for you?
It was just a typical morning. I was getting ready to maybe run some errands. I was having some coffee, and I realized that he wasn't in the house, so I started to get concerned about it. And when he didn't come home at all, I notified the police.
And what were you told on that police call?
I was originally told that not enough time had passed to consider him missing, and that I should just try to reach him by phone and wait.
And were you aware of any relationship that was tearing between Mr. Gibson and Mr. Chase?
No, but they were always busy, and so I just assumed they were fine because they were always working.
And you stated that Mr. Chase was always working very late and
Yes.
very early?
Yeah, very late.
And have you any reason to believe if he was working late on something else other than his job?
The only thing I think he might have been working on was his secretary.
And you stated that in the interview that you believe that was because you heard her on a phone call you made to the office?
Multiple times.
Did you ever call the office besides those couple of times as checking in on your husband?
I mean, I had called several times. I'm not exactly sure when.
And may I call evidence the prosecution's evidence 4, I believe.
Okay, so that's the difference. Yeah. So are you looking for the prosecution? Okay, because there's this one's.
And this map, can you tell me, this is where your whereabouts were about, right?
I guess so.
And did you visit the school itself anytime during that day?
No, but I was in the town.
And you said you were meeting with Miss Orley.
Right.
And when you go in, and you said you went grocery shopping, do you know where you exactly went grocery shopping?
This town over.
All right, thank you very much.
You're welcome.
I have no further questions, Your Honor.
Any redirect?
Yes, Your Honor. Ms. Chase, so even though you did not know the value of the life insurance, you were still aware of it?
I was.
All right. And how well did you know Mr. Cooper? Or do you know him?
He's a colleague, but he doesn't work in the same wing of the building as I do, so I only see him on occasion.
Do you know what kind of teacher he is?
He's a biology teacher.
Okay. Your Honor, may I speak with my counsel for a moment?
Sure.
Now, Ms. Chase, in regards to the affair that you suspect between your husband and his secretary, did you ever confront him about it?
I did, but to no avail. He just said he was working late, trying to build his business.
So he denied it?
He did.
Did you continue to suspect afterwards?
I did.
And you never confronted him again about it?
I did not.
Okay. In that case, I think that's all we have. Thank you.
Any re-cross-examination?
Yes, Your Honor. May I see Exhibit F for the defense?
Which one is that? Life insurance, for sure.
You said you were aware of your husband's life insurance policy?
Yes,
Were you aware when it was first issued out?
it was. Yes, I was.
And can you tell me the date?
I can't tell you the exact date, but I think we did it up, he started it up maybe about a year after we got married.
And do you know what year that would be?
Probably about 2013.
And you said you weren't aware that it was never signed.
I was not aware of that.
And you were never aware of the basic amount or that you were the sole beneficiary from it?
I knew I was the beneficiary. I knew the original amount, but I didn't know that the amount had changed.
I have no further questions, Your Honor.
Anything further?
No, Your Honor.
Ms. Chase, you may step down. Thank you. Does the defense rest?
Yes, Your Honor.
Is there an application to have any rebuttal witnesses?
No, Your Honor.
So the prosecution rests as well?
We do rest, yes.
Does either team have any applications for the court at this time?
We do not.
No, Your Honor. All right. So the next thing that we're going to do is take the summations from each of the parties. And we're doing very well on time. It's customary to allow the attorneys that are going to close a moment to compose themselves. So what I'd like to do, even though we're ahead of schedule, I'm going to have would 5 minutes be enough time? All right, so why don't we take a 5-minute recess? I'm again going to ask the jury not to discuss the case amongst yourselves or anyone else. And we'll reconvene in 5 minutes for summations. It's easier to have them in front of you than to go hunting.
Makes it flow really nice. I would like, yeah. Would it be possible for me to have exhibits C, D, and F? C is the best.
Okay. And you're entitled to any evidence, it doesn't matter what you produce. Yep. Okay, and if you change your mind up there, you'll be out of debt.
In New York,
Okay. I'll take the defense closing argument.
Your Honor, may I approach the stand?
Yes.
Your Honor, ladies and gentlemen of the jury, imagine for a moment that you're driving your car down the road, just going about your day, when suddenly another car comes flying out the side road and hits you head on. You go to the hospital, and a few days later, the police come in and tell you you're under arrest. You're confused. You ask why. You're considered responsible for the car accident the other day. This doesn't make any sense. The car collided with you, hit you in the side of your car, leaving you in a T-bone. You tell this to the police, but they say, well, we found some dents in your car from the accident, and we really didn't feel like talking to the person in the other car, so we put the guilt on you. That's exactly what's happening today, ladies and gentlemen. Throughout this case, you've heard a lot of different claims, different pieces of evidence thrown around, but it's clear that the prosecution has failed to prove beyond a reasonable doubt that our client is guilty. They have not given any real motive for Mr. Gibson to have committed this crime. Their witnesses have been shown to be an unreliable source of information, and they were unable to properly identify the real culprit. The prosecution put forth the police, who failed to do their job and investigate all potential culprits, not because of any real reason, but because they thought that would be an inconvenience to them to investigate every potential murderer. Not only this, but from the evidence that they did investigate, they did not even convey it properly to the police team, as can be seen in Exhibit D, where 2 knives are missing from Mr. Gibson's knife set, but it was only reported that 1 knife was missing. The prosecution brought forth the forensics team as well, who proved also to be unable to properly recover the evidence at the crime scene at the garden, and perhaps even making more mistakes during their analysis, as seen in the bag the body was recovered in. The forensics team members were so careless they left a footprint on the bag while they were attempting to recover it, despite the fact that their entire job is to handle evidence with care and caution. In addition to this, prosecution brought forth a school janitor who seemed too panicked to even convey an accurate description of what happened at the garden scene, as in her interview, she contradicted herself at least once. Meanwhile, our client stood only to lose from Mr. Douglas Chase's death. He lost a friend, he lost a partner, and the ripples left by his death are causing Mr. Gibson to lose his livelihood. So the question still lies, if Blaine Gibson didn't commit this murder, then who did? Well, if I may, allow me to paint a picture of what really happened. Ashley Chase, the widow of the deceased, is responsible. She believed that Douglas was not being a good husband or father. She suspected him of entering into an affair with his secretary, Vivian Jackson. Not only this, but with her husband's life insurance policy on the line, regardless of if she knew the value because she was not aware that it was potentially null, Miss Chase had more than enough motive to kill her husband. We have no reason to disbelieve this story either, as the police did not investigate the Chase's home and cannot confirm that Miss Chase did not have access to the same type of knife that is suspected to be the murder weapon, or the same type of bag that the body was recovered in, because both could have been accessed by anyone. They were common kitchen utilities. Now you might be thinking, Miss Chase is accounted for. She wasn't at the crime scene when the body was buried. Actually, Your Honor, would it be possible for me to access, which evidence piece was it? The map of Ashley Chase's?
I think it was 4 or D.
It was for Ashley?
Yeah. Okay. Thanks. Is it still here? Oh, sorry. So, as seen in Exhibit E, Miss Chase was not at the school during any irregular hours. She was in the town of Saugerties during regular hours from 1 to 3:30 p.m., but she was not at the school. So how could she have committed this crime and buried the body in the garden? Well, that's where her co-worker and accomplice, Mr. Cooper, comes in. You see, Mr. Cooper, he is the biology teacher. He has access to the garden, and he has admitted that he goes into the garden sometimes without student knowledge. He is aware of Ashley Chase. They know each other fairly well, even though he denied knowing her. You see, because Mr. Cooper stated that the body was found somewhat shallow, or the grave rather was found somewhat shallow. He guessed in his interview that the main reasons that this might be is because either the criminal was rushed or that they wanted the body to be found. My guess is that Ashley Chase got Mr. Cooper involved, asked him to bury the body to cover her own tracks, and therefore Mr. Cooper panicked and in a rush because he didn't want to be involved in a murder case, buried the body somewhat shallow in the garden where he had access, possibly hoping to get rid of it later on in a different, more safe area. But then, when his students came along, he and they were working in the garden, digging up soil samples, all of a sudden, they dug up the body. Realizing his mistake, he panicked, rushed them off site, and reported it to the police to eliminate his own suspicion. Now, ladies and gentlemen of the jury, our client, Mr. Gibson, can only be considered guilty if you believe beyond a reasonable doubt that he did this. If any of you believe for even a second that my story has any merit whatsoever, that is reasonable doubt. So I will reiterate, Blaine Gibson did not commit this crime. Ashley Chase did. That would be all.
Thank you. I'll take the prosecution's closing argument. Thank you, Your Honor.
Your Honor. Ladies and gentlemen of the jury, today I'd like you to imagine with me that you're tending to a garden with one of your partners, a man you trust, a man you've known since college, and through all in all, you have mutual respect for each other, and you each protect each other's endeavors. But one day, you decide that the garden maybe isn't what you wanted with your life. Maybe sometime you want to get out, do more, spend time with your family, who just love you, and you've been away from since you have put so much time into your garden. And you bring this up with your partner, and he attacks you, and then he stabs you, and he buries you, and he takes a spade to that beautiful garden you built together, and he digs it all up, making it gray, dull, lifeless. Nothing can sprout from that garden anymore. That's what Mr. Gibson did to Mr. Chase and to his family, and to that business. All Mr. Chase wanted was out. Mr. Chase wanted to just leave. He wanted to spend time with his family because he couldn't do that as much when he's working so hard. But Mr. Gibson didn't want that. He wanted to be able to make money, get in, get out. without any problems. But Mr. Chase had to put in all his time. Mr. Chase had to put in all his effort. And Mr. Gibson was just there, as reiterated by Mrs. Vivian Jackson. There was no reason, there was no purpose for this murder. There was no way that Mrs. Chase could have committed it. She was out all day with her friends, with her family. Her kids were at her mother's because she wanted to spend time with her friends. And she wanted to go out because it's the middle of the summer. Who doesn't want to go out? She doesn't have work. But because Mr. Chase wanted to put in minimal effort, because he didn't want to do anything for Mr. Gibson wanted to put in minimal effort, because there was no reason for him, he decided he would take the life of an innocent man, a man who worked hard, a man who worked good, an innocent man through and through, just because he didn't want to do anything and he just wanted a little bit of money, because he's a greedy man, and a man who's also lazy. Through the evidence that we provided today, the knives that were missing, through evidence D, 2 knives were missing in this photo, but only one was, because Mr. Gibson was scared. He wanted to get rid of the knife. He was scared the police would catch him, because there were 6 stab wounds with serrated knives. That knife set is all serrated knives. And since the knives that he used to stab him could be synonymous with him digging up the roots of his business, of him not wanting to do anything, of him just profiting off the seeds of doubt that he planted into Mr. Chase's mind. A man who convinced Mr. Chase he was his friend, but he wasn't. Because in the end, no matter what, he was just a greedy, lazy man who wanted to betray him, and he wanted to only just for profits. And Mr. Cooper was a man, Mr. Cooper and Mr. Chase, they barely knew each other. As Mrs. Chase said, they've seen each other in the hallways 1 or 2 times. Mr. Cooper barely even recognized her and that she was working there. They couldn't have plotted anything together. They couldn't have done anything together because they didn't know each other. They weren't buddies. They weren't friends. They were work colleagues. They had no connection. But today, the opposing counsel wanted to put blame on an innocent woman who was just trying to care for her family and wanted to spend time with her husband. They tried to put blame on an innocent biology teacher who cared for his students and cared for their garden. They wanted to put blame on innocent people that were just trying to do their lives, like Mr. Chase, when Mr. Gibson ripped him away from his family. And the reason I say this, all this, that there were seeds of doubt, that there was that he wanted to get out of the business. When the forensics team confirmed that there was blood of both of them in the house, we could surmise together that maybe they got into a fight, because maybe sometimes friends fight. But there was no reason that Mr. Gibson had to take a knife from his drawer and stab Mr. Chase 6 times in the ribs with it. There was no reason to go that far over a fight, over a business. But he did, and he ended it with that purchase, with that action, because of an uncontrollable anger and uncontrollable rage. And I also ask you, why would Mr. Chase why would Mrs. Chase ever want to kill her husband? For money? She wasn't aware of that it was $1 million. She was only aware she was getting money. There was no reason, in the end, for her to murder her husband. A man who provided for her, a man who helped her as much as he could, who worked late nights because he loved his family so much. And a man who, all in all, was just a hard-working, innocent man who wanted nothing but the best for his family, his friends, and Mr. Gibson, who took that away from him and his family. That's all, Your Honor.
Thank you.
Thank you.
Ladies and gentlemen, in a few moments, you'll begin your deliberations. The defendant, Blaine Gibson, is charged with murder in the second degree for the death of Douglas Chase. I'm going to describe to you the law that's applicable to these charges. You are the sole determiners of the facts, whereas I am your guide with regard to the law in this matter. So as you go through your deliberations, I'd ask you to recall the elements of the crimes and the principles of law that I'm about to describe. Under our law, a person is guilty of murder in the second degree when, with intent to cause the death of another person, he causes the death of such a person. Intent means conscious, objective, or purpose. Thus, a person acts with intent to cause the death of another when that person's conscious, objective, or purpose is to cause the death of another. In order for you to find the defendant guilty of this crime, the people are required to prove from all the evidence in the case, beyond a reasonable doubt, both of the following two elements. One, that on or about July 26, 2023, the defendant caused the death of Douglas Chase. And two, that the defendant did so with the intent to cause the death of Douglas Chase. If you find that people have proven beyond a reasonable doubt both of those elements, you must find the defendant guilty. If you find that people have not proven beyond a reasonable doubt either one or both of those elements, you must find the defendant not guilty. Intent does not require premeditation. In other words, intent does not require advanced planning, nor is it necessary that the intent be in a person's mind for any particular period of time. Intent can be formed and need only exist at the very moment the person engages in prohibited conduct. Let me talk to you a minute about motive. In particular, the difference between motive and intent. Intent means conscious, objective, or purpose. Thus, a person commits a criminal act with intent when that person's conscious, objective, or purpose is to engage in the act which the law forbids. Motive, on the other hand, is the reason why a person chooses to engage in criminal conduct. Intent is an element of murder in the second degree, and that element must be proved by the people beyond a reasonable doubt. Motive, however, is not an element of murder in the second degree. Therefore, the people are not required to prove a motive for the commission of the crime. Nevertheless, evidence of a motive or evidence of lack of motive may be considered by you. For example, if you find from the evidence that the defendant had a motive to commit the crime charged, that is a circumstance you may wish to consider as tending to support a finding of guilt. On the other hand, if the proof establishes that the defendant had no motive to commit the crime charge, that is a circumstance you may wish to consider as tending to establish that the defendant is not guilty. I'd like to turn now to a couple of the principles, the fundamental principles of our law. These principles set us apart from most of the other nations in this world. Throughout all of these proceedings, the defendant is presumed to be innocent. As a result, you must find the defendant not guilty unless, on the evidence presented at this trial, you conclude that the people have proven the defendant guilty beyond a reasonable doubt. In determining that whether the people have satisfied their burden of proving the defendant's guilt beyond a reasonable doubt, you may consider all of the evidence presented, whether by the people or by the defendant. In doing so, however, remember that even though the defendant introduced evidence, the burden of proof remains on the people. The defendant is not required to prove that he is not guilty. In fact, the defendant is not required to prove or disprove anything. To the contrary, the people have the burden of proving the defendant guilty beyond a reasonable doubt. That means before you can find the defendant guilty, the people must prove beyond a reasonable doubt every element of the crime, including that the defendant is the person who committed that crime. The burden of proof never shifts from the people to the defendant. If the people fail to satisfy their burden of proof, you find the defendant not guilty. If the people satisfy their burden of proof, you find the defendant guilty. So what is this term reasonable doubt? How do we define the term reasonable doubt? The term proof beyond a reasonable doubt is used to tell you how convincing the evidence of guilt must be to permit a verdict of guilt. The law recognizes that in dealing with human affairs, there are very few things in this world that we know with absolute certainty. Therefore, the law does not require the people to prove a defendant guilty beyond all possible doubt. On the other hand, it is not sufficient to prove the defendant is probably guilty. In a criminal case, the proof of guilt must be stronger than that. It must be beyond a reasonable doubt. Now, in this case, the defendant did not testify. I charge you as a matter of law that the fact that the defendant did not testify is not a factor from which any inference unfavorable to the defendant may be drawn. It's his absolute right not to testify. He may have wanted to testify, and his counsel didn't let him. You may draw no inference whatsoever from the fact that he did not testify. There are two types of evidence, namely direct evidence and circumstantial evidence. In this case, the people contend that there is circumstantial evidence of the defendant's guilt. Let me briefly describe the difference between direct and circumstantial evidence. Direct evidence is evidence of the fact based on a witness's personal knowledge or observation of that fact. A person's guilt of a charged crime may be proven by direct evidence if standing alone that evidence satisfies the jury beyond a reasonable doubt of the defendant's guilt of that crime. In this instance, in this case, there were a number of factors that witnesses testified to about their direct knowledge. You heard a witness testify that she looked out a window and saw something in the woods near the garden that looked like someone was dragging a heavy object. That was direct evidence. Circumstantial evidence is direct evidence of a fact from which a person may reasonably infer the existence or non-existence of another fact. A person's guilt of a charged crime may be proven by circumstantial evidence if that evidence, while not directly establishing guilt, gives rise to the inference of guilt beyond a reasonable doubt. I would observe that in many instances, I would say most instances, crimes of this nature are not committed with a number of witnesses present. So it is common for cases such as this to be determined by circumstantial evidence as opposed to direct evidence. Your verdict in this case must be unanimous. That means that after you go through your deliberation, if almost all of you agree to one verdict or the other, that is not a, you may not, let me restate that. Let's say almost all of you were to hypothetically determine that the defendant was guilty. Almost all of you is not sufficient for a finding of guilt. If after your deliberations you cannot reach a unanimous verdict of guilt, then your verdict must be not guilty. Molly, since you are in that chair, you will be the chairperson of the jury. So what will happen in just a moment, the jurors are going to be escorted into their deliberations, and you will conduct your deliberations. When you have reached a verdict, you will notify the bailiff. Don't tell him what the verdict is. Just tell him that we've reached a verdict. And then we will reconvene, all of us will reconvene. You will come back in, and at that point, I will ask you to rise and deliver the verdict. Your verdict will be guilty of murder in the second degree or not guilty of murder in the second degree. All right? Okay. Bailiff, if you escort the jury.
All rise. You did the right thing.